Good morning, everybody. Hi and welcome, and thanks for joining us on this early morning. We hope everybody's staying safe, of course, and weathering what are clearly unprecedented times. You know, we don't have polls in this presentation, but I kind of wish we did, because I'd love to take a poll on how many people are, for example, in PJs or wearing slippers, or maybe have dogs in the room with them or kids. Well, you can all just assume, since there's no video, that I'm in a three-piece suit myself. But let's move forward with some introductions. Susheela?
Good morning, everyone. My name is Susheela Canada, and I am a privacy and litigation attorney here at Farrell, Braun & Martel. One thing I will note that in addition to doing privacy work, I also, or I should say, in addition to helping companies gear up with compliance, I'm also helping companies prepare for potential litigation that may come out of the CCPA. So there are a few angles to this. However, prior to practicing law, I actually worked as a cybersecurity consultant with PricewaterhouseCoopers. And one of my primary roles during that time, this was in the early 2000s, was to simulate hacks. And that's actually what led me eventually to law school. So this is a full circle moment for me. And I really enjoy learning and chatting about this. So feel free, not just during this call, but even after this call, to reach out. Thanks, Nate.
Thanks. And I'm Nate Garhart. My practice focuses on trademark, copyright, and advertising, as well as internet law. And that latter area has had me very busy with privacy and privacy policies for clients in the near term. I want to note at the beginning that we don't usually do this as a webinar. We don't usually do this presentation, or frankly, haven't done many, if any, presentations as a webinar. So this is a first time for us. So please bear with us and our issues with the platform and or technology. We'll take questions at the end. At that point, you'll want to unmute your line, and do note that this call is being recorded. But for now, please keep your line muted and do hold your questions for the end. A couple other things. I want to note that there are a lot of words on these slides. Usually our presentations aren't so wordy as far as the slides go, but at the end of the presentation, everybody's going to get a copy of this. And so we wanted to include a significant amount of information on the slide so it would be useful as a resource. Of course, it's not the be-all to end-all resource. You're going to have to dig a little deeper than what we provide in the slides, but it does give you a good basis to understand the CCPA and the laws that we're talking about. So getting started, I always think a little levity is helpful in times like this. I saw this recently, and I realized that it's not often I'd have the opportunity to show this to a group of people that would be so attuned to actually get the joke. So I thought it was very apropos here. So what are we going to talk about today? We're going to talk about privacy laws as shown in the California Consumer Privacy Act. We're going to show a few of the GDPR differences. That's the European privacy law, just because most people are more familiar with that law at this point. It's been around for a while. Companies have, to some degree or another, decided to or not incorporate some of the requirements of the GDPR. In connection with the California Consumer Privacy Act, we'll be talking about what needs to go in your privacy policy. We'll also talk about your data security and what you need to do to make sure you comply with the requirements of the CCPA. And then we'll talk about data breaches and notification requirements under the CCPA and other laws on data breach. So we're here. We're here, and we've got two new key laws to talk about, but there's a lot to talk about in privacy and privacy regulation. And now that we have specific laws around it, it's a little easier to get into the nuts and bolts of what needs to be done. The first question that comes to mind is this just a joke? I mean, I don't know about you all, but when the GDPR came into effect in May a couple years ago, we got a ton of emails every day, literally dozens, if not hundreds, of emails saying that a privacy policy had been updated. And it got to the point where there was so much fatigue that, I don't know about you, but I stopped reading the emails, and I certainly didn't read the policies. And, you know, do your customers read the policies? I don't know the answer to that. But at the end of the day, whether your customers are affected directly or whether they feel they're affected by the policies or not, compliance with the law, should you qualify to have to comply with the law, compliance with the law is key. And it doesn't matter that much if really the consumers have gotten fatigued and they've stopped reading the emails or the privacy policies. And I want to just, my favorite of these jokes is this one. I would obviously love to be able to walk into a shop at all, but I would definitely give my business to a shop, especially an Italian one, that posted a notice like this in writing. So let's talk about privacy. So generally, people tend to understand, or it has come to be the case, that it's understood there are certain privacy rights that individuals should have, whether they actually have them or not. Basically, there's a sense that people should have the right to access their personal data that's been collected by a company, to make sure that data is accurate, to have that data deleted, either by asking or even without asking, to have the ability to limit the way that information is used, to obtain a copy of what a company has as far as their personal data, and to object and control the use, processing, and transfer of their data. Now, the laws don't necessarily incorporate or reflect all of these rights, but these are out there as kind of a backdrop for the laws, and the laws do implement some of these and most of them to one extent or another. So what is the legal landscape? We have two key laws. The first is the GDPR, that's the European law. It's been enforced since May of 2018. It actually came into effect before that, but their enforcement started in May of 2018. And it applies to the information of EU citizens and residents. The California Consumer Privacy Act, the CCPA, just came into effect in January of this year, although enforcement is delayed. And we'll talk more about that as we move forward. There are other state laws concerning privacy, but most of them are about, well, all of them right now are about data breach. There is some legislation on the horizon. Washington, we'll talk about it later, but other states have laws in the works. But for now, it's really the CCPA and to a lesser degree, the GDPR that we need to be concerned about. So can you ignore it? Well, let's talk about the GDPR first. The GDPR really applies to any company that's collecting information of people in the EU or EU citizens. But the real question is it enforceable against companies here in the US, that is US companies? Well, it could be, either directly or indirectly. First of all, if you have a lot of assets in the EU or subsidiaries or affiliates in the EU, you certainly need to be concerned about the GDPR. Do you have significant business relationships in the EU? One to look out for, one hook to look out for is contracts. If you have distributors or the like that are in Europe and they are including, it's usually called a data privacy addendum to contracts, and they're calling for you to comply with the GDPR, you need to be aware of that and take steps to make sure you either amend that contract and get it to the point that you want it to be, or that you are complying with the GDPR. Finally, could there be future reciprocity deals with the US? There certainly could be. There's nothing now, we don't have a federal law, but there could be in the future, so it's something to keep in mind. What about the CCPA?
Okay, I'll take it from here. Thanks, Nate. So before I get into some of these threshold requirements, just by way of background, as I'm sure many of you may know, California is leading the charge when it comes to consumer privacy rights. And many states are looking to California to see not only how the state enforces, but also how private actions play out. So there has been some discussion about how, you know, the CCPA started out as let's target the big tech giants like Facebook and Google, especially after the Cambridge Analytics debacle. But there is significant impact on small companies, whether you're a large winery or a small winery. The CCPA is not just limited to large or small tech companies. So with that in mind, let's get into the threshold requirements for a company to determine whether the CCPA applies to it. So the CCPA applies to for-profit companies collecting information from California residents if such company, 1, has an annual gross revenue greater than or equal to 25 million, or 2, obtains personal information of at least 50K California residents, households, or devices annually, or 3, gets at least 50% of its annual revenue from selling the personal information of California residents. So one way to look at this is that you do not have to be a company based in California or have a physical presence here in order to fall under this law. So just keeping with the theme of, can I ignore this? Well, it depends. You have to be careful. You may have third-party contracts which require you to comply and include indemnification clauses. Another thing to keep in mind is that to fall under the at least 50,000 consumers annually prong, you only need 137 unique California visitors to your website per day from who you collect personal data. For example, IP addresses, because that is considered personal information. Additionally, the 50K annually prong applies to, quote, consumers, households, or devices. And the definitions of household or devices, they're not clear. And just as a side note, roommates who are in one apartment, maybe that's a household. Your Alexa device, your Amazon Alexa device, your Google Home device, that could be considered here too. Actually, it's funny, I said Alexa, my Echo Dot just lit up. Okay, Nate, next one.
So really quickly, I just want to interject one thing. You're going to hear a lot that we say there's ambiguity or things are not clear. And I just want to back up really quickly and touch on how the CCPA came into effect. So an individual and his entity, the individual is Alistair McTaggart, put together a ballot initiative for the California ballot, and it was a privacy law, and it was fairly strict, much more like the GDPR. Had a lot higher level of requirements, a lot broader private right of action, and the legislature got very concerned very quickly when businesses started to freak out about it and call the legislature, the state legislature. So the state legislature felt it had to do something. It negotiated with McTaggart and said, basically, we'll put a law into place. Let's agree on what that law will basically say, but know that if we don't come to an agreement, we're going to tie your law up in court for a long time. So it's better for everybody if we come to some agreement. So they had to do it very quickly. So they threw the law together, broad brush strokes, and what we got was the CCPA. And it was kind of thought, we'll work it out and we'll clean it up as we move forward. Well, with that comes a lot of ambiguity, a lot of unintended consequences, and that's what we're seeing now. And that's why in this presentation, you'll hear us say quite often that there's some ambiguity here, or things are just not clear, and we're going to have to see how it works out. So with that backdrop, and sorry for the interruption, we'll move forward.
Let me just add one more thing to that, because I often deal with clients who have questions about certain definitions. And right now, the general approach is read it in the broadest terms. Until we get some case law and further guidance, it's best to read these terms in the broadest way. Okay. So we're going to talk a little bit about enforcement outside of California. In terms of practicality, these are going to be, the California AG is going to get a civil judgment under the CCPA if there are violations. However, because companies outside of California may be implicated, it's likely that these judgments, these California judgments will be enforced by courts in other states unless the commercial conduct takes place wholly outside of California and the company is not doing business in California, meaning it's not actively engaged in any transaction for the purpose of financial or gain or profit in California, which I don't think applies to most folks on this call, but we did want to flag that. All right, now in terms of penalties, under the CCPA, you can be fined up to $2,500 per violation, and that fine can be increased up to $7,500 per violation when a company's actions are intentional. Separately, and we'll get into this later, there is a private right of action for data breaches under the CCPA, and that's something to keep in mind, and it's keeping many of my clients up late at night, making sure that they've got procedures in place to fight off such litigation. With respect to the GDPR, it's up to 20 million euros or 4% of global revenues. They've also got a private right of action. I do briefly want to share with everyone on the call some of the penalties that have been brought under the GDPR, some of the fines. The British Airways was hit with a $230 million fine. Marriott was hit with a $123 million fine. Google in France was hit with a $57 million penalty. And all of this revolves around a breach taking place, improper notification, improper security measures in place, exposing customers and their information even after the breach had occurred. So CCPA practitioners, I guess that's one way to put us, we're closely following the GDPR fines and penalties to get an understanding of how high some of these damages numbers may look.
One other thing I want to add here is that the AG, when enforcement starts, the AG has made clear that it's not just going to be the Google and the Facebook that it's looking at, and instead is going to be looking broadly and looking at small as well as large companies that come under the purview of the Act. And what he has basically said to date, what his comments have shown, is that he's not looking to slam somebody who is technically in violation but trying to do the right thing. Instead, what he's going to be looking for is companies that are simply ignoring the Act, that know well that they should be complying with the Act and are simply deciding it's just not worth their time and effort. He wants to make it clear that it is worth time and effort and it needs to be complied with. So while there is ambiguity here, and while we don't know a lot about the law, the lesson that we take away from it and looking at the penalties is that you don't have to stay up at night making sure every last I is dotted and T crossed, but instead you have to be making concerted efforts. We think you have to be making concerted efforts to come in line with the law in order to avoid these penalties that we expect to come, and we expect they'll be very significant. Sushila, back to you.
Yep,
Yep.
Thanks, Nate. I was on mute. So briefly, let's touch on how the CCPA defines personal data. So again, it's not just something that's linked to an individual, but it could be a household. And some examples include, there's the obvious stuff like your name, your address. I mentioned earlier an IP address, email address, social security number, driver's license number, passport number is in there now, and other similar identifiers. And of course, characteristics of protected classifications under California federal law, such as age, race, gender, and sexual orientation. Biometric information is also included. And so that's your facial recognition, your fingerprints. So the definition is quite broad, like I mentioned earlier.
And the key with data is, and here are some other examples, but the key with data is to know what data you have And I often talk to clients, and I'll talk to the marketing folks, and they'll tell me they collect, you know, names and addresses and emails, and that's it. And then I talk to the IT department of the same company and tell them what I understand they're collecting. And the IT department says, oh no, the programs that we have in place just collect a lot more information than that. And so it's key to have it be a company investigation and look into not just what you think you're collecting, but what IT can tell you you're actually collecting, whether that's an in-house IT company or if you're using a vendor. You really need to get clear on what data you actually are collecting. So the CCPA embodies some, but not all, of the generally understood privacy rights that I talked about previously. The right to know what personal information is collected, what's sold or disclosed to third parties, and who those third parties are, at least by category. The right to say, no, you may not sell my personal information. The right to access that information, to see what information you have. The right to equal pricing regardless of exercising privacy rights. That is, you can't penalize somebody because they don't let you sell their information. I would note here that this doesn't mean you can't have a loyalty program, even though it seems that that gives certain rights to people that would be different than rights that those who don't give as much information get. It's been made clear that loyalty programs, so long as they're done right, will be acceptable. And finally, it does embody the right to be forgotten. So where does all of this show up? In large part, it shows up in the privacy policy, because a lot of it is about disclosure. So what does your privacy policy have to disclose? First of all, you got to tell the categories of the information you're collecting and why you're collecting that information. In one version of the regulations, and Sushila will talk about the latest version in a little bit, but in one version of the regulations, it said that for each category of information, you had to provide the purpose of the collection of that category. Now it says you don't have to tie them all together. That is, you don't have to have an explanation for each category. You can just have a general explanation after you provide all of the categories. My recommendation at this point is to still break it up. It's not that hard to say, we collect your email address and we use that in order to provide you with the services that we provide, the communications we provide about your account, etc. It's not that hard to do, and in case it goes back and forth again, which it well could, I would say break it out and go to the kind of the bottom of what might be required. It's just not that hard. So second thing that has to be disclosed in the privacy policy is a description of consumers' rights to request the information. You also have to include that the consumer has a right to request deletion of their information and the limitations on that right. We'll talk about that a little more later, but you don't have to delete people's information even when they request it in all situations. Then the category or categories of personal information that you have sold or disclosed, shared in the last 12 months, or that hasn't occurred. And we expect that most companies are not sharing information, giving it to third parties, except in connection with, let's say you use MailChimp or something like that in order to provide you with email services to your consumers. That would be a situation where you're sharing it, but it's less likely to be something that has to be disclosed specifically, although we would suggest including that kind of information because it's easy to do and it doesn't take away from your business. So what else does the privacy policy need? Well, it has to provide a clear and conspicuous link on the home page that says, do not sell my information. And if somebody clicks that, they're automatically opted out of having their information sold. Big caveat here, if you don't sell personal information, and it's included in your privacy policy that you do not and will not sell personal information, you're not going to have this link on your homepage. Again, I expect that applies to most people here, so you won't have to have the do not sell my personal information link on your website. You do have to ensure every consumer or any consumer can access that link if you are selling personal information without requiring the creation of an account. Creating an account would obviously require them to provide more information, and you can't require them to provide more information in order to get to a do not sell link. You do have to include the statement that consumers' rights will not be limited because they restrict the sale of their data. Again, probably not a big deal because most of you are not selling data. And finally, and this one does apply and is important, you have to include a designated means to submit the request. So the request, for example, to be deleted, the request to see what data you have, etc. You have to include a toll-free number. Clients very often say to me, what about email? Can't I just do email? And the answer is, if your relationship with the client, with the customer, is only electronic, that is, you don't have a place where they can come into contact with you, purchase goods, give you information. If you're only collecting information through your site, then you can do it by email and just provide an email. But if you do have another place, like a tasting room, etc., where individuals can come into contact with you and provide personal information, then your privacy policy has to include a toll-free number to which consumers can call and make the requests, submit the requests under your privacy policy. So a little bit about consent. What kind of consent do you need to get from people to collect their information? Well, the good news is in the US and under the CCPA, it's generally opt-out. That is, you can collect somebody's information, you can use somebody's information, you can even sell somebody's information unless they opt out. That is, that they tell you, no thank you, please don't. And the CCPA for selling information is supposed to include an opt-out button that they are going to define. The latest regulations deleted their suggested opt-out button, so we haven't seen that yet. But at any rate, only important, that opt-out button is only important if you are selling information. But again, with opt-out, it's opt-out for everybody in the US, all your US consumers, except, and I expect this doesn't apply to many wine companies, but it's except for children age 13 to 16, who you need to get an opt-in from. And if they're under 13, you have to actually get the opt-in from their parent or guardian. So again, with wine sales, I expect it's not likely you're collecting information. Your site is not aimed at children under 21, and in fact, you have age gating on your website. So shouldn't be something you have to be concerned about. But if you have a related site, maybe you have other products that you do allow children to access. If that's the case for some reason, keep these in mind. And just comparing it to the GDPR, again, the US is an opt-out country. GDPR is actually opt-in, and that's why we got all those emails back then, because you actually had to click and consent to the collection and use of your information. So what about deleting personal data? We talked about the fact that both the GDPR and the CCPA recognize a right to be forgotten. Well, under the CCPA, you have to delete a consumer's data when it's requested by the data owner, and only if it's requested by the data owner, and only if it's no longer needed for your business relationship or your business purposes. So what are some examples? Let's say, for example, you need to keep certain information in connection with sales tax payments. Maybe that can be de-identified. I frankly don't know if that's the case. But if you do need a person's information in order to comply with other laws, to show that you verified the age of a person, for example, you can hold that data as long as you need it for that purpose. That's different than the GDPR, where there is some ability to keep it if there's a legal reason that you need to keep it, but not so much a business purpose. And backing up to the CCPA, an example of a business purpose would be if a consumer is a member of your club, your wine club, and they ask for their data to be deleted, you wouldn't have to delete it if deleting it would interfere with your ability to provide them services under the wine club. Now, you probably don't have to tell them that technically, but of course you probably would send them a communication that says, hey, we'd love to delete your data, But if you want to do that, you're going to have to quit the wine club because we need that information in order to provide you with the services of the wine club. Now, in that situation, you could only keep the data that is directly necessary for the wine club, and you would have to delete the other data. But going back to the GDPR, note that under the GDPR, as soon as that data is no longer necessary for the purpose it was collected, it has to be deleted by the company, even if the consumer didn't request it. So it's a good bit easier here under the CCPA.
Okay, so next we're going to talk about data security and breaches. As many of you may know, the CCPA requires that companies subject to the CCPA implement and maintain, quote, reasonable security procedures and practices. And often the question comes up, what's reasonable? And that is yet to be determined by the courts. The case law has not developed here, but I direct my clients to the 2016 California Data Breach Report from the California AG's office. And what that report says is companies should refer to what I refer to as these 20 data security controls that were published by the Center for Internet Security. And what these controls include, they've got your traditional guidelines for what you must be doing, frankly, anyways, taking an inventory of your hardware assets, taking an inventory of your software assets, continually monitoring any vulnerabilities in your IT systems, making sure appropriate folks have admin privileges and other folks do not, making sure you have malware defenses, making sure you have a procedure in place if you need to recover data, making sure you have proper wireless access controls. So for those who are interested, I highly recommend just quickly Googling 20 data security controls published by the Center for Internet Security. This is a great starting point. Back in 2016, then AG Kamala Harris noted that a failure to implement all applicable controls, quote, constitutes a lack of reasonable security. So it's not yet clear if the current AG will follow this guidance, but he hasn't said otherwise. So this is a really great starting point.
And really quickly before we move on, absolutely, again, this is an area where we have to wait and see. But what we would suggest in the meantime is to document. Note what you're doing. Make it clear that you are taking steps. Make it clear that you are training employees, that you are getting everybody on the same page and taking steps to reach this reasonable protection limit. It's going to be important as far as the enforcement by the AG. Now, could be different in connection with the private actions.
So one other thing on the document side, HR policies and IT policies can also be updated to include 1 or 2 paragraphs on the CCPA. That's an easy way to document reasonable steps by your business. Just thinking down the line in terms of litigation, I often suggest to clients that if you've got something, not just on the IT side, but maybe on the HR side, an employee manual, etc., you're showing that you took, quote, reasonable steps to be in compliance. And frankly, maybe you went above and beyond. So that's important. And folks should think about talking to HR, marketing as well, and maybe looking at those policies. So, okay, the private right of action. So under the CCPA, an individual consumer may recover anywhere from $100 to $750 in statutory penalties. So they don't have to prove actual damages. These are statutory penalties per data breach incident if the breach was due to 1, unreasonable security procedures and practices, and 2, the compromised data included non-encrypted and non-redacted personal information, as the term personal information is defined under the CCPA. So it's very unlikely an individual is going to file a lawsuit from anywhere to $100 to $750. What's more likely is we're going to see class action lawsuits with significant damages numbers. For example, very easy, for a company to have a million or so folks who are subject to a breach. And all of a sudden you're looking at a massive damages number. Attorney's fees may be included, punitive damages may be included. The case law is yet to develop on that, but that's what we're preparing for. And in fact, we've seen 2 lawsuits recently filed, which invoke the CCPA, and one is against Salesforce and another one is against Ring. So we're closely monitoring those 2 lawsuits. All right, so separately, in California, there is a data breach notification law under California Civil Code 1798.82. And what this notification law does is it lays out the contents of a notice if your business is subject to a data breach. It's very detailed. There are many requirements, but some examples include, the date, the types of personal information that were or are reasonably believed to have been the subject of the breach. So that's quite broad, right? Were or are reasonably believed. So that requires a deep dive into what data was compromised. So it does take significant efforts to determine this. Additionally, you're required to provide a toll-free telephone number and address of the major credit reporting agencies if the breach exposed social security numbers or driver license numbers. And unfortunately, many of us have seen these notifications. Home Depot rings the bell. Separately, you'll see notifications which include some discretionary information, like what the business has done to protect individuals whose information has been breached, and advice on what steps those individuals can take to protect themselves going forward. And in fact, you folks on the call probably have heard of companies offering free credit monitoring services just because there is a business side and goodwill side to this. Again, that's not required, but I would venture to say that many consumers expect it today. I will add that this law only applies to California residents, and of course, other states have different notification laws that will apply to residents of those states. Just one side note, for example, Alabama sticks out because they actually require you to shred and delete anything that's left over that may have been compromised. I'm certainly not an attorney licensed to practice in Alabama, but these laws vary quite a bit.
They do, and when we see breaches, and we've worked with a lot of clients on breaches, what we have to do is go state by state. Well, we go into the client's data, determine where the individuals whose data they have reside, determine which states are affected, go through the requirements of each state, and comply with each state's laws. So it is a significant undertaking. It's very doable though, and we do it on a unfortunately fairly regular basis.
So I'm just going to add one, sorry, Nate,
Yeah.
do you mind going back to the last slide? Just want to add an additional point on data breaches and what we're doing to prepare for that. In addition to having lawyers lined up for this, you should also have vendors, IT vendors, and forensics folks lined up and prepared to deal with data breaches. It's not uncommon for a breach to happen on a weekend and a vendor gets a call, what do we do to shut this down immediately? So we have partnered with various vendors to make sure that we offer a full service package here on this. And in fact, like I shared before, prior to practicing law, that is what I did. So this is definitely a grouped collaborative effort to make sure a company is prepared.
That's a really good point. And one other very practical thing I would note with a data breach is one thing that I saw in the early days of data breaches that doesn't tend to happen anymore is that if there was a data breach, a company would immediately say, put out a message on its website or otherwise that says, we've been breached, and we want you to take steps, blah, blah, blah. Well, the problem with that is they hadn't actually closed the vulnerability yet. And so then they were tipping off the hacker, if you will, that they knew about the breach and that they would be closing it. So the hacker would dig in somewhere else and create another vulnerability. And so it became much harder to close those breaches. So the point of this, just from a practical perspective, is don't talk about the breach until you talk to your attorneys and the necessary vendors to make sure that that vulnerability is closed.
Right, and in fact, that's why some of those fines I mentioned earlier against British Airways and Marriott were higher than they otherwise would have been, just because they allowed these vulnerabilities to continue to exist despite being aware of them.
So moving on a little bit, you've again heard us talk about, well, we're not sure how some things are going to play out, or there's ambiguity, or something's not clear. Well, we thought we'd get some amendments and regulations that would clarify things. And there was a round of amendments, and then we've had a couple rounds of regulations. But to be honest with you, there's just not that much to see here. It answers a couple of questions, created a couple of new questions, but at the end of the day, Sushila can talk about some of the specific things that we've seen in the regulations.
Sure. So some folks may know that just recently on March 11th, the California Attorney General's Office released a second set of revised draft regulations under the CCPA. They got about 100 comments back in February, most of them very critical, where businesses were just confused and complaining that there wasn't clear guidance. So I don't know if the second set of revised draft regulations necessarily are less confusing or address everything, but I appreciate the AG's attempt to do this. So some noteworthy changes include deletion of the opt-out button graphic, but that's interesting only because the final regulations, we expect the final regulations to still have some kind of opt-out button because the CCPA text requires the AG to develop a recognizable and uniform opt-out of sale logo or button. So expect more on that. Another noteworthy change was notice at point of collection. And I'm just going to read this out so folks are clear on that. So the new regulations state a business that does not collect personal information directly from a consumer does not need to provide notice at collection to the consumer if it does not sell the consumer's personal information. And the AG did this to address notices by entities that do not interact directly with consumers. Another noteworthy change was employee notices. So now a business collecting employment-related information is not required to provide a link to its privacy policy in its notice at collection, whereas it was in an earlier draft. Another thing folks are talking about includes privacy policy requirements, and that's what a business must state in their online privacy policies. So now businesses must identify the categories of sources from which personal information is collected and identify the business or commercial purpose for collecting and selling this information. I would venture to say companies who are already working on this should have this information readily available, but businesses should be aware that this was a change in the second set of revised regulations. So the written public comment period ends this Friday, March 27th at 5 p.m. Pacific, if anyone is interested. We expect another set of revisions or a final proposed set of regulations in a few months. Originally, the thought was that we would see another set of revisions or a final proposed set in April, but things might get delayed just because of COVID-19 concerns.
So looking back at that bullet point that says notice at point of collection, one of the things that was aimed at is data scraping. I don't think this is going to be an issue for most wine companies, but I do think it's interesting and it's worth talking about quickly because it has become a pretty big issue in the general tech industry. So data scraping is where a company goes online onto public websites and collects information available on those websites. So a great example would be LinkedIn. There are companies that go on LinkedIn's website, they never log in, they never have an account, they just scrape the public website for information. So it could be people's names and the companies that they work for. All of that is publicly available for the most part without logging into LinkedIn or otherwise clicking through any kind of agreement with LinkedIn. It's just sitting there and it's available to be scraped. So LinkedIn is a great example because they sued about it. And LinkedIn sued at that time under the Computer Fraud and Abuse Act. And the court said, no, sorry, if this stuff is public, it's not fraud for somebody to go out there and scrape it. So if the scrapers are out there, is it okay under the California, under privacy law? And it's not clear. That is, now this point in the regulations was added to make it clear that if the personal information they collect is not sold, that you don't have to give notice to the individuals. But what if you are selling that information? You're collecting all this stuff off of LinkedIn and you're selling that personal information in a non-de-identified form. So it's including names and companies, which would clearly be personal information. Well, the regulation would say that notice must be given to the individuals, but how do you give that notice to the individuals? What if, for example, you don't have an address for the individuals? Maybe you could send it to that place of work you collected. I'm just not sure. This is another situation where it's just not clear how this is going to play out as we move forward.
So I touched on this earlier, but you know, the COVID-19 concerns, and not surprisingly, just a few days ago, there were over 3 dozen business organizations that sent a letter to the California AG's office asking his office to delay enforcement of the CCPA to January 2nd of 2021. Basically, there's a concern, not surprisingly, that you know, businesses don't have the operational capacity right now to bring their systems into compliance. We haven't heard anything from the AG's office in response to this letter, but we anticipate more companies are going to line up behind this request, and of course we are following that.
So what about other laws? We definitely see the potential for new laws. In fact, Alistair McTaggart, who I mentioned earlier, has a new California ballot initiative that has stronger protection for certain information, has opt-in, not opt-out, for selling of information, and requires permission in order to use personal information for targeted ads. For example, those annoying things where you're on or 10 minutes earlier, you were on Amazon looking at some product, and now you're in your Facebook page, and lo and behold, there's an ad for that very product while you're surfing around in Facebook. Well, that kind of thing under the new act would require permission before it could be implemented by companies. Other states are also looking at laws. Washington has a law in the legislature right now that is actually being held up because it has a controversial provision that creates a private right of action for any violation, not just data breach violations, and companies are obviously very concerned about that. What about federal legislation? Well, it's going to be necessary at some point because as more states include legislation on privacy, there's going to be a situation where there are conflicting provisions. That is, complying with what's required in one state could cause you to violate the law in another state. If that's the case, the federal government is going to have to step in, and we expect that to happen. We were thinking 1 to 3 years, considering the way that Congress works or does not work right now. But now with the current situation, it could be even longer, but we're keeping an eye out for it, and we do expect federal legislation at some point.
So I'm going to add one other thing on the federal legislation. And last month, towards the end of February, the California AG asked federal lawmakers to reject any online privacy legislation that would restrict the CCPA enforcement under the CCPA. So expect a bit of tug and war there as well. All right, so let's talk about some key takeaways based on this yet developing in early stages of the CCPA. So, you know, some main things that you can do include identifying the type of personal information you collect, receive, and share. Post a clear and complete privacy policy online. Get consent when necessary, and maybe even when not required. One side note on that is I've spoken to clients who have said, you know, even my non-California customers expect the same level of privacy that we're giving to California customers. They don't understand why they would be treated any differently. So that's, you know, I know that's a business decision, but that is some feedback I've received. Make sure you collect data for specific and legitimate purposes. Keep data up to date. Don't keep data any longer than necessary. Process data securely under documented programs and protocols. And remember that encryption and redaction are a company's first line of defense against CCPA claims. And I shared with you earlier that I worked, you know, in cybersecurity prior to practicing law. And that was my first question. Is the data that's been compromised, was it encrypted? So that's really, really important. I cannot stress how important that is. And if folks have questions about that, you know, I'm happy to answer those questions and also put you in touch with appropriate vendors. Lastly, review your insurance coverage and consider negotiating additional cyber insurance coverage. Shameless plug here, we have some fantastic insurance lawyers who are constantly dealing with cyber insurance coverage. This is also a developing area, but insurance companies are well aware of these issues.
And in connection with that, we expect many people are going to be contacting their insurance companies about issues with business interruption because of what's going on right now. And another shameless plug, there is an available program coming out in the next week or so, couple of weeks from us, from Forella on that subject. So keep your eyes out for that. But if you're talking to your insurer about other things, you might as well ask about this as well and take a look at your cyber insurance coverage. The final thing I would add on the takeaways is, look, we understand a lot of companies are not subject to the CCPA, but even if you're not subject to it, you should definitely consider its requirements and implement some of them just to reflect your understanding and appreciation of the expected privacy rights that people think they have or should have. So just because it's not directly applicable to your company because you don't meet certain thresholds that we discussed, it's still important that you consider it and again, reflect your respect for what people think they have as far as privacy rights. So thank you so much for joining us. And now is the time where you could please let us know if you have any questions. You can certainly email us any questions and we'll get right back to you. Or if you want to ask now, that's fine. In order to do so, we'll need you to unmute using the little button on your screen. And do again, note that this is being recorded. So by asking a question, you'd be consenting to our recording of your voice and your question here. Any questions? Sounds like not. We'll keep an eye out for emailed questions. Again, we thank you. And remember, oh, was there a question?
Hi, yeah, I was wondering if we could get a copy of your slides. From today's.
You will. Great question, because you were ahead of me in that I was just going to say you'll all get a copy of this presentation by email. And so keep your eyes out for that.
And another thing, if folks are interested, or maybe we'll just include this anyways, we can provide a link to those 20 security controls that I mentioned earlier. Margaret, I can send you that
Yep.
link. Okay.
Great. Well, thank you again, everybody, and good luck with your sparkling isolation. I wish everybody well.
Thanks, everyone.